Okay, hello and welcome to Liberty Nations LNTV. I'm Mark Angelides, and today we're very lucky to have our in-house expert, Scott Cosenza, here to talk to us about a topic that is raging through the headlines at the moment, FISA warrants. Now, we've all heard about them, but what are they? What are they used for? How are they different from regular warrants? And more importantly, what are the implications for them in light of the recent Nunes memo? Now, here to give us all the analysis and insight is Liberty Nations' Scott Cosenza. Scott, what are FISA warrants, and can I buy one at the local 7-Eleven?
Hi, Mark. I don't know that there's an English or British or American differentiator here. I say FISA warrant, you say FISA, tomato. But the FISA warrants first came about in American jurisprudence. I believe it was 78 that the Foreign Intelligence Surveillance Act was passed into law. And with all these different security laws that we have seen since then, the Patriot Act and its legacy, those have been granting that act and the courts that were authorized under that act more and more power to surveil people. Originally, it was conceived of that it would not surveil Americans or U.S. citizens, and the procedure for surveilling U.S. citizens under FISA allows for the government basically to have a less stringent hurdle to overcome before they're allowed to listen in on what Americans are saying.
Well, that's got to be good for us. All right, so what's the difference between a FISA and a regular warrant?
Okay, so a regular warrant, the jurisprudence that governs that, it goes back to 1968. There was an omnibus crime bill that, in addition to giving penalties for listening to other people for wiretapping or eavesdropping on electronic communications, it also provided for a specific kind of delineation of what the courts would require, or what the law required for policing agencies before they could be granted a warrant. So this all comes from our Fourth Amendment. The Fourth Amendment of the United States Constitution requires that probable cause be supplied to a judge who issues a warrant for unreasonable searches and seizures, and this would be unreasonable to listen into somebody's communications unless a warrant were present under the regular thing. So Title III warrants is what they're usually called. Fans of the Wire TV show have a PhD sort of in especially if you've seen all the seasons in what's required there. But there are basically three prongs for the to get a warrant. So a regular cop once, or an FBI agent once, thinks that I'm doing something that I shouldn't be doing, and it doesn't involve, well, you could be a foreign agent, but it doesn't involve that, just a standard drug deal or something like that would happen wholly contained in America between the U.S. citizens, and they would have to supply probable cause to the court that a crime is about to be or has been committed, okay? So you could do that through various means of testimony and evidence. You'd also have to say there was a probable cause that the warrant is likely to intercept communications that will prove that crime. So if I'm just talking to my mom, who presumably is not involved in the cocaine transaction, that's not helpful. I have to be discussing these things with one of my partners in crime, as it were. And then you also have to provide probable cause that the wiretapping is necessary or exhaustion has been used, so that they have tried other means of investigations that are less burdensome or invasive to me, or it's impossible for them to do so. And the court would rule, seeing those things, the totality of the circumstances, decide whether or not to grant a warrant. Under a FISA court, none of that's present in the FISA warrants. Okay, those are difficult burdens to overcome, and wiretapping is usually, is seldom used because of that. But under the FISA court, only probable cause that surveillance is of an and I'm reading now so I'm very accurate, is authorized, that the surveillance is of authorized person or group for purposes relating to the gathering of foreign intelligence or preventing terrorism. So Carter Page can be accused of perhaps being a foreign agent. That's all they have to say, is that we have reason to believe this person may be a foreign agent. Not we know he is, or we have conclusive proof, but we have reason to believe that he may be, and that's all you need. All those other qualifications go by the wayside, which, as you might imagine, is why it's much more popular an option for somebody who's looking to listen in on somebody else. Why go the long way through the thorny thistles, and you can just take a walk to the FISA court, where nobody's ever going to find out, unless we have this scandal like we do now, that you did the dirt.
So, am I right in thinking this is a FISA warrant has become more of an investigatory tool as opposed to a tool for finding evidence with which to prosecute?
I think that's right. I think that given the nature of foreign espionage and also acts of terrorism, that perhaps was the point of it. So the reason why warrants are required by courts for evidence is for them to admit the evidence. So
Right.
the police in America, in whether they're the cop on the beat or the Federal Bureau of Investigation, they don't really have to worry about their own police agency arresting them if they illegally wiretap somebody. These people are basically untouchable. But if they want to take that evidence that they have and then bring it into court and say, Scott did something bad, and here's we can prove it because he talks about it right here on the phone. Well, the court will say, you just listen to his phone calls? No, we're not going to entertain that evidence. And so that's the exclusionary rule, and that is how those courts exercise their own check on the executive power and the legislative power by refusing that evidence. But in FISA courts, I mean, if you're just using that information to go perhaps kill foreign actors or for your own information about who to isolate who may be foreign agents, it becomes less important. So I think the answer to your question, Mark, is yes. One of the things that we know is that, and I maybe should have included in my earlier answers, that FISA courts also do not disclose their information. So it's all super secret. You know, we all know what occurred in the news just last week with the release of this memo and what a big deal some people made out of it because it was classified. Well, that's not true with respect to a regular warrant or a Title III warrant, where at the end of the investigation, you may not be able to get the transcripts of such a warrant, but you certainly will be able to get the application for the warrant and also the fact that a warrant was issued. And none of that's true for FISA. So FISA is this closed-door, very secret, and very permissive way to get a warrant. Now, we've heard about how tough these applications are that they submit. Well, one thing we know is that the courts almost always grant these applications. I took a quick look. Go ahead, I'm sorry.
So this was going to be my next question. It seems like an incredibly powerful tool and one that should be used wisely. So, but how often are these things actually granted based on how often they're applied for? Do we have that figure?
I took a quick look before we started recording, and it was until 2013 there were 35,529 requests for either warrants or actual break-ins for people's houses or pen registers. And for all those 35,529 requests put before the court, there were 12 denials. So only in 12 instances did they say you haven't met the burden required by law. Now you could think, having seen the testimony and evidence of Mr. Comey and his colleagues, that the FBI are just that conscientious and that good, or you could think, like I do, that what we have here is a massive invasion of privacy by the FBI and federal government into the lives of Americans and others, and it's unacceptable and impermissible under our constitutional law scheme, where our rights to privacy are supposed to be not violated unless there's a darn good reason to go ahead and violate it with supervision of the court to make sure that it's the least extent possibly invasive of an American's privacy.
It's quite scary, isn't it? Well, thank you, Scott, for joining us, and a huge thank you to you for watching at home. Don't forget you can check out an accompanying article on this topic and our other breaking news and analysis on libertynation.com.